One of the things I really love that you talk about with litigation is you talk about how both people head in with their best possible outcome, right? Their best case scenario,
Yep.
and how that actually sets you up for a very difficult scenario to start with. So nobody's thinking of the other person. Can you tell us about?
Yeah. Yeah. Good question. What I mean by that is court and a lot of conferences that occur in a very litigation heavy negotiation model. So even mediation sometimes, depending on how it's run, depending on who runs it and depending on how it's sort of facilitated, is very positional. And positional negotiation is very, very different from interest-based negotiation. And so,
Okay, so say that one again.
okay.
Right? I love that. I want to hear that one again.
Okay.
It is
Positional.
positional.
Positional-based negotiation is very different from interest-based negotiation.
Right.
Yeah?
Okay.
Do you want me to explain it?
Mm.
Yeah. Yeah. So when you negotiate from a position, you're stating your best case. And most often it's that you've sat down with your lawyer, you've given your lawyer really detailed instructions about the history of your relationship, the contributions each of one of you have made throughout the relationship, the value you each have brought. And then you're considering the future and what that might look like for you, and create, and sort of you get advice about what that might look like. We're talking property settlement at the moment. And when you get that, and if you're given advice that is very definitive, and this is your best case scenario, no lawyer, no good lawyer will ever give you a percentage that the judge will definitely give you.
Right.
They absolutely cannot do that. And no, anyone that says they can does not understand family law. Okay. All they can ever do is give you a range. But what they'll do is set you up for the best possible, highest range in your favor. So the best outcome for you will be the highest percentage within that range. So all you hear, and let me tell you, I used to be one of these lawyers. That's how I was trained. So I know exactly what happens. You leave, all you are is hearing that percentage, right? So if it's 60 to 70%, and that's best case, all you hear is 70%. So then you go into any negotiation, you go through the entire negotiation process wanting your 70%. But remember, your spouse is sitting with their lawyer doing the exact same thing. They're sitting down, giving them their version of the instructions, which are going to be very biased toward themselves. So they're going to be different already. Those instructions about the value they created in the relationship, the contributions they made, the needs they've got. And so their lawyer is going to give them advice based on those instructions. And that's going to look very weighted in that person's favor. And they're going to hear the higher end of that. So then you have two people at opposing ends of the spectrum, because the lawyers haven't done anything wrong. They've given their clients advice within the range of outcomes at the best possible ends of the spectrum based on the instructions that their clients have given them. But what they've ended up with is really positioning their clients. And so now they have polarized views of what the outcome ought to look like. So when you come into a negotiation positionally, you come in, I want that because I'm entitled to that. And this is why I'm entitled to that. And then the other one comes in truly believing that I want this because I've been told I'm entitled to this because of all the things I've done, right? And what in my view, that is short-sightedness, because it's not appreciating how settlements are reached. It is only empowering the clients with their best possible case to lead them to disappointment in a few months' time when the actual negotiation happens. And then at the negotiating table, whether it's in a mediation or on the doorstep of a trial, which is what happens, don't be fooled, 2% of matters get a judge to make a decision. The majority of the matters are settled out of court. And what I mean by that is, even though you're within the court process, maybe the court will send you to a conference, a mediation, any other types of negotiation to get you to talk. So the court's doing what we're promoting. And most of the time, it's when you've paid thousands of dollars and you have barristers primed and ready to argue your case. And then on the day of the trial, it settles. The settlement happens because each of you are pushed a little bit more and a little bit more and a little bit more until you get to a spot that feels about in the middle of where each of you lawyers had told you from the beginning. Okay? But that is very positional. What you're saying is, I've been told this and that's what I want. And they've been told the same. Where interest-based bargaining is different is exactly in the words interest-based. It's about the interest behind the goal. So yes, you are given legal advice, 100%, but the advice doesn't occur in a vacuum. What we like to understand when we say we provide an interest-based solution is we understand your instructions and then we want to understand your spouse's instructions. Tell us what your spouse is telling their lawyer. Tell me about that. And then we play sort of devil's advocate. What about if that were true? Or what about if he were able to prove that? Or what about if she really did do that? Or what about blah, 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 blah. And so really try to have our clients question that advice. We make sure it's very, very put in a way that is within a range, absolutely. But we don't set our clients up with a percentage. We really try not to talk percentages. We try to talk about outcomes. So we talk about it in the perspective of what is there to divide? What have we got in this asset pool? And what is it that means the most to you for you to retain? And if your life moving forward looks like this and you need an ongoing income stream, or you need to retain this house because of its sentimental value, or you need a house with 4 bedrooms and a pool, or whatever it is you need, then that's how we negotiate for you in a way that still fits within the law. And don't worry, we still do the percentages in the background. We still make sure that you are getting your right and just legal outcome. But the way you see it is based on what matters most to you. So that's when we say we're creative. That's what we do to creatively negotiate, really, really sensibly, to trade certain things that don't matter as much to you, to for other things that matter more. Sometimes trading, a money in a bank account, or for a bit more super, or paying having the children's school fees paid until they're 18 is really valuable to some people, more so than something else. So it's just about how to really appreciate and understand what everyone wants, and then negotiate in a way that is about that, with their real interests at play, and really understanding what matters to them, what matters most, underlying what it is they're looking for. So then it doesn't become about percentages. It comes about the outcome. It becomes about the actual tangibles.